suppose you're at a social gathering and you have someone who is an acquaintance who approaches you. They know that you are a mental health professional. You know that they're engaged in whatever profession they're engaged in. And they start talking to you, and you're having a nice conversation, whether it's about your children or plays or whatever it might be. You're just having a nice conversation. And the conversation takes a turn where the person begins to talk about some of their own problems. They begin to discuss more and kind of more and more detail so that you begin to get uncomfortable. Because you think they're really no longer just having a nice chat with me. When does a professional relationship start? Does it start when that person begins to talk about their personal issues? Does it start at the point at which you have identified yourself as a mental health professional? Does it start at the point at which you've had a clear agreement, an informed consent process, saying, this is who I am, this is who you are, this is why you're coming to get services from me? When does it start? So setting and intent are what seem to make the difference about whether a professional contact has been made. Okay? And so what we need to do in a social context is to be really clear that we're not in the role the person thinks we're in. Or say, it sounds like you really could use some help. I can make some referrals for you. I'm your friend. Of course, I can't provide that kind of service. Well, this is an interesting piece. Even if I don't become a therapist for that person or an assessor, the first point of contact in my professional capacity is the point at which confidentiality applies. It's not that there's a relationship. It's the first professional contact. Where it gets a little bit muddy is when the person approaches me at a party and I have no sense that this is a professional contact at all. And I'm driving home, this time with my partner, and saying, gee, so-and-so told me that they're breaking up with their partner and they're going through a nasty child custody battle and blah, blah, blah. And then I find out later that that person thought that they had told me that in confidence. Okay? Now, I could probably win that one, but it points to an important dimension of confidentiality. If we believe, from my perspective, if we believe that a person has approached us in our professional role, then we should assume that confidentiality for that information applies, even if no other duty exists at all. Even if we've referred them on, we've said, I can't work with you because I don't work with serial killers. I cannot then go and talk about them at all. Confidentiality is kind of a strange duty. And it's strange because unlike most of the other duties we have as clinicians, it attaches like that and then it's permanent. It doesn't go away, permanent to the extent anything is permanent, unless there's a clear exception or we get permission from this person who may not even be our client. Okay? So it happens right at the outset. It begins fairly quickly. Even if we haven't entered into what we might consider to be an ongoing professional relationship. Simply making getting a call in my practice and making a referral, I can't then turn to you and say, I got this call from, Barbara Streisand's brother-in-law's daughter. Wow. No, why? Because this was in my professional capacity, confidentiality applies. And the whole idea is that it would reduce the likelihood of people seeking our services if they were to believe, and I'm afraid that they already do to some extent, but if they were to believe that their information about their seeking services or the type of service they're trying to obtain or the problems they're having are going to be revealed to the public or to other people by the clinician. That's why confidentiality attaches early in the relationship or early in the process, and it doesn't require an ongoing relationship. Okay? Now, confidentiality, as you all know, is a fairly broad ethical concept with legal teeth, for sure. There are laws about it all over the place. But it applies to our day-to-day practice work. When we're assessing people, when we're doing supervision, when we're doing therapy, when we're talking about cases, confidentiality. With our colleagues, we're talking about confidentiality applies. It's the day-to-day ethical duty with pretty significant legal teeth. Privilege, which I just want to talk about for a little bit, is much more narrow, and it is a legal duty. And it has to do with a privilege by patients to not have their information from a psychotherapeutic relationship, that is psychotherapist-patient privilege, divulged in a legally related proceeding. So it's fairly narrow. And privilege law is an odd duck Because all of us actually, although most of us don't walk around thinking this, but all of us actually have a duty to come forward to the courts to present information in the interests of justice. So if I witness a car accident, even though many people will just say, I don't want to get involved with this.
If I get a subpoena to appear in court, I can't claim privilege and say that I won't show up.
A psychotherapist, however, can say, this is a privilege owned by my client. And this privilege allows them to not have information be put into the legal system, because the legal system and the society values that relationship and wants to support its existence and the exchange of information in that relationship. Okay. The two cases that I was mentioning regarding privilege, one of them is called the Story case, the People versus Story. Gary Dean Story was a Vietnam vet, I believe Vietnam vet, who had assaulted a woman in the mid-70s, very kind of vicious assault, and he was brought up on charges, and during the process of trying him, I don't know who raised the issue, although it seemed to be pretty obvious at that point, I guess, to a number of folks, but they believed that he was having a significant mental disturbance, and so one of the issues was, should he receive psychiatric services? And he received psychiatric services as a condition of probation. After a year of therapy with a psychiatrist at the VA in Palo Alto, his psychiatrist wrote a letter to the court saying, there are no guarantees about this thing, so it was a wise psychiatrist, and he seems to have improved in a number of ways, and the likelihood of his being violent seems to have decreased significantly. So essentially, the letter was sent to the court to say he's fulfilled the terms of his probation. Around the same time, in 1976, there was another crime with a similar MO where a woman was murdered, and they brought in Story for questioning. And they initially, I think, thought he had committed that crime, but it was determined that there wasn't sufficient evidence to connect him with the crime at all, and he was let go. More than 25 years later, so 2002, the DA reopened the case and brought charges against Story because there was some evidence that now linked him to the crime. In prosecuting the case, the district attorney wanted to do something very interesting. The district attorney said, I want the records to Gary Dean Story's previous psychiatric treatment at the VA in the mid-70s. And the trial court agreed. Well, Story's attorneys objected and said this material is privileged. I would have predicted, because of usually how privileged cases go, the court orders the treatment. Of course they're going to be able to get the record. But the appellate court said no. They said that privilege is not waived simply because a person has a court-ordered treatment. They said, no, DA, you can't have it. Very surprising. The other case that's actually ongoing right now is a case involving a psychologist who was seeing a client who got into a bad car accident. And this client started psychotherapy after the accident. The accident seriously physically injured the psychologist's patient, damage to the other party, but the other party was not physically injured. The other person sued the patient, okay? So far it makes sense? Right? Other person sued the patient, and they said, I want all of the records from the psychotherapy to determine whether this person, the patient, has a history of driving under the influence or while intoxicated, because the patient was driving under the influence of, I believe, alcohol at the time. And the judge surprisingly said, oh, sure, because it's relevant. What? Privilege is not about whether it's relevant. Privilege actually exists when the information is relevant and could actually help decide a case. Privilege still exists. Relevance is, to be a little bit silly, irrelevant. Privilege exists unless a number of very finite exceptions. So the American Psychological Association and California Psych Association put in amicus briefs, that is letters to the appellate court when this was appealed, to say, wait a minute, privilege isn't waived simply because a court deems there to be relevance of the testimony. It's got to go beyond that. And since in this case the defendant was not raising his or her mental problems as a defense, if that was in fact the case, there might be one or two other circumstances. The reason I'm giving you these two contradictory cases is to suggest that if you encounter a situation relevant to or where privilege arises, assert it and let the judge and the attorney sort it out and fight it out. So we want to, just like confidentiality, assume it exists and then let them fight it out. If your attorney says, no, this isn't privileged, you have to send off this information, okay. But for the most part, you're going to assert privilege and then let the courts decide. Because courts tend to be very, at times, idiosyncratic about how they determine whether privilege applies in a particular case.